January 20th, 2026. 9 justices, 1 hour of argument, and a single moment, roughly 20 minutes in, when Hawaii's own attorney conceded a point so damaging that legal observers in the room immediately started predicting how this case would end, 5 months before the actual written opinion confirmed it. I want to walk you through that argument, not the ruling, the argument itself, because the questions the justices actually asked that day tell you more about how this court reaches a decision than any headline summarizing the outcome 5 months later ever could, and because almost nobody actually goes back and reads what happened at the podium once the final ruling has already generated its own separate wave of coverage. Quick housekeeping. I go back to the actual oral argument transcript in cases like this, not just the final opinion, because the questions justices ask often reveal their thinking more directly than the careful, edited prose of a written decision ever does, stripped of the months of revision and careful wordsmithing that goes into a final opinion. If that is useful, subscribe and turn on the bell. 2 seconds, and let's set the scene before we get into the argument itself. By January of 2026, Wolford versus Lopez had already traveled a long road to reach the Supreme Court's argument calendar, a road worth tracing in some detail because it shapes exactly what the justices had in front of them by the time argument actually began. Hawaii's law, Act 52, passed in 2023, flipped the traditional common law presumption for licensed concealed carriers on private property open to the public, treating every business as off-limits by default unless the owner affirmatively said carry was welcome, through a posted sign, spoken words, or something in writing. Jason Wolford and several fellow Maui permit holders, backed by the Hawaii Firearms Coalition, had sued, arguing the law's sweeping list of default off-limits locations functionally nullified their permits across nearly every place they actually went during an ordinary day. The gas station, the grocery store, the dry cleaner, none of which had taken any active position on firearms one way or the other, meaning a permit that had cost them time, money, and a background check to actually obtain, provided essentially no practical benefit across the overwhelming majority of their daily routine. A Ninth Circuit panel had already reviewed Hawaii's law alongside a similar California law back in September of 2024, splitting the two in an instructive way, striking down California's stricter, sign-only version as too rigid, on the theory that requiring a specific physical sign effectively defaulted most businesses into a ban through simple inertia rather than a genuine choice. Since most small business owners simply never get around to posting a sign about an issue they had not specifically thought through either way, while upholding Hawaii's more flexible version, which allowed consent through a sign, spoken words, or writing, as a comparatively more considered approach that gave owners several easy paths to signal an actual, deliberate choice. The full Ninth Circuit declined to rehear the case in January of 2025, and the Supreme Court agreed to take it that October, limiting its review specifically to how the Second Amendment applies to privately owned property open to the public without reopening the broader Bruin framework itself, a deliberately narrow question that shaped exactly what both sides could and could not argue once they reached the podium, foreclosing broader arguments about the historical tradition test, generally in favor of a tightly focused fight over this one specific mechanism. So, on the morning of January 20th, 2026, attorneys for both sides stood before the 9 justices to argue a case that would ultimately affect concealed carriers in 5 states. A genuinely high-stakes argument, even though it addressed what might sound on paper like a narrow technical property question. Representing Hawaii was Neil Katyal, a former acting Solicitor General of the United States with extensive Supreme Court argument experience, someone who has stood at that same podium dozens of times across a career spanning both Democratic and Republican administrations, facing a bench that included at least 3 justices, Thomas, Alito, and Gorsuch, whose prior opinions in other Second Amendment cases had already signaled real skepticism toward this general category of restriction, meaning Katyal was arguing an uphill case against at least a working plurality of justices before he ever said a word. Here is the moment worth walking through in detail, because it is exactly the kind of exchange that experienced Supreme Court watchers treat as a genuine, if informal, signal of where a case is headed, long before any written opinion confirms it. Chief Justice Roberts pressed Katyal directly on the nickname critics had attached to Hawaii's law during the litigation, the vampire rule. Drawn from the old folklore image of a vampire that cannot cross a threshold without being specifically invited in, Roberts asked Katyal to confirm whether that nickname accurately captured the underlying legal mechanism Hawaii had actually built, whether the historical tradition the state was relying on really did amount to the old common law idea that a person needs an owner's affirmative consent before entering, the exact structure critics were mocking with the vampire comparison. Katyal conceded that it did. That single concession, agreeing that your own client's law functions exactly the way its harshest critics describe it, is rarely, if ever, a winning moment at the podium, and several legal commentators covering the argument live flagged it in real time as a signal the state's position was struggling to gain traction with the court's apparent majority, a read that turned out 5 months later to be exactly right. It is worth pausing on why this specific style of questioning is so revealing, beyond just this one case. Supreme Court justices frequently use a memorable label, whether one coined by the litigants themselves or one that emerged from press coverage of a case, as a shorthand tool during oral argument, specifically to test whether an attorney will resist a simplified characterization of their own position or accept it. An attorney who pushes back hard against an unflattering label, insisting it mischaracterizes the actual legal mechanism, is signaling confidence that the label is a distortion. An attorney who concedes the label is accurate, as Katyal did here, is either genuinely confident the label does not actually hurt the underlying legal argument or has made a strategic judgment that resisting a memorable, already widely circulated nickname would cost more credibility than simply accepting it and moving on to defend the substance. In this specific instance, the concession appears, in hindsight, to have signaled the latter far more than the former, since the substance of Hawaii's defense struggled just as much as the label suggested it might. It is worth understanding why that specific concession mattered so much doctrinally, not just rhetorically, since the distinction between a rhetorical misstep and a genuine doctrinal admission is exactly the kind of nuance that gets lost in a same-day news summary of oral argument. The entire case turned on whether Hawaii could point to a genuine historical tradition, under the framework the court itself established in 2022's Bruin decision, justifying this particular default consent mechanism. If Hawaii's own attorney was willing to agree that the law functioned exactly like the folklore mechanism critics were using to attack it, a right that evaporates unless specifically, affirmatively invited across every single threshold, that concession made it considerably harder for the state to simultaneously argue the underlying historical tradition. It was relying on supported something narrower or more moderate than what the vampire rule label implied. Once you concede the mechanism, you have effectively conceded what actually has to be historically justified, and justifying a rule that broad, using only the specific, narrow historical examples Hawaii had assembled, turned out to be more than the state's argument could bear. A gap between the breadth of the conceded mechanism and the narrowness of the available historical support that the eventual majority opinion would spend considerable length walking through in exactly the terms this exchange had already previewed. Those historical examples are worth walking through in some detail, because this is where the argument's substance, beyond that single memorable exchange, actually lived, and because understanding exactly why these specific examples failed tells you something durable about how this court evaluates historical evidence generally, not just in this one case. Hawaii's attorneys pointed to a handful of scattered 19th century property statutes as historical support for the default consent mechanism, including a provision tied to Louisiana's Black Code and an isolated 1893 Oregon poaching law, restricting entry onto private land for hunting purposes. During argument, justices pressed on how either example actually connected to the specific modern rule at issue, a statewide default covering every commercial establishment a licensed carrier might visit, for any reason, not merely land use restrictions tied to hunting, or a specific, historically bounded regulatory scheme tied to a deeply troubled period of American legal history. Several justices specifically probed whether a single regional poaching statute governing a narrow, specific activity, hunting on someone else's land, could genuinely be stretched to support a blanket, statewide rule covering ordinary commercial transactions entirely unrelated to hunting, a gap in reasoning Katyal struggled to fully close during the exchange. The questioning suggested several justices were unconvinced these isolated, regionally specific examples could bear the weight of establishing a genuine, nationwide historical tradition broad enough to justify Hawaii's sweeping modern rule, skepticism that the written opinion 5 months later would confirm in far more detail, explicitly rejecting both examples as too narrow and too regionally isolated to satisfy Bruin's historical tradition test, the same test the court had established in 2022 specifically to require this kind of close, demanding historical connection rather than a loose, generic analogy. Justice Kavanaugh's questioning during the argument focused on a different, more practical thread: the actual, real-world burden the law placed on ordinary permit holders going about an ordinary day, pressing on how many businesses a typical Hawaii resident might visit, without any of them having taken an active position either way on firearms, and what the practical legal exposure looked like for someone with a valid, lawfully issued permit. Simply running errands under those conditions, a specific, concrete style of questioning Kavanaugh has used repeatedly across several Second Amendment cases, grounding abstract legal doctrine in the kind of everyday scenario an ordinary person actually experiences, rather than a purely theoretical hypothetical. Kavanaugh's questions returned repeatedly to concrete, everyday scenarios rather than abstract doctrinal categories, asking counsel to walk through specifically what a permit holder was supposed to do, practically, when entering a business that had never posted anything and never said anything one way or the other. A question Hawaii's side struggled to answer in a way that did not ultimately confirm the practical bind permit holders found themselves in under the existing law. That line of questioning previewed a piece of reasoning that would become central to the majority opinion itself: Justice Alito's eventual description of how an ordinary day of errands, a stop for gas, a trip to the grocery store, a drop-off at the dry cleaner, could turn a licensed, law-abiding carrier into a repeat criminal without them ever intending to break a single law, language that reads, in retrospect, almost like a direct continuation of the specific hypothetical scenarios Kavanaugh had been pressing counsel on 5 months earlier. Justice Jackson's questioning that day previewed the dissent she would eventually write, focusing specifically on the property law dimension of the case rather than the gun rights framing dominating most of the argument. She pressed on whether a business owner's underlying right to control who enters their property under what conditions was itself being treated seriously enough by either side's framing, suggesting even during argument that she viewed this case as resting on a fundamentally different legal foundation than her colleagues did, a foundation rooted in ordinary property law principles rather than exclusively in Second Amendment doctrine. Jackson specifically asked counsel for the challengers to address why a business owner's traditional common law right to exclude visitors under conditions of the owner's own choosing should be treated as constitutionally suspect, simply because the specific condition involved a firearm, rather than any other condition an owner might reasonably impose, a line of questioning that got relatively little attention in contemporaneous coverage of the argument, but that maps almost precisely onto the dissent she would eventually write. That framing would become the core of her dissent 5 months later, joined by Justice Sotomayor, arguing that requiring a visitor to obtain permission before entering someone else's business, armed, reflects an ordinary, well-established property right, no different in kind from any other condition an owner might set on entry. A genuinely serious alternative reading of the case that simply did not attract a majority of the court. It is worth also giving attention to how the challenger's own attorney fared during that same hour, since oral argument is never one-sided, and the questions posed to the side that ultimately wins can be just as revealing as the questions posed to the side that loses, a balance that a summary focused only on Hawaii's rough moment would miss entirely. Counsel for Wolford and the other Maui permit holders faced pointed questions of their own, particularly from justices probing how far the challenger's theory would actually extend if adopted, whether a ruling in their favor would leave property owners with any meaningful tools at all to exclude firearms, or whether it would functionally eliminate any practical distinction between a business that welcomes carry and one that does not. A genuinely fair concern given how sweeping some interpretations of the challenger's core argument could theoretically be pushed. This line of questioning is exactly what eventually produced the specific, careful language in the majority opinion emphasizing that individual business owners retain full authority to post a sign, give verbal notice, or otherwise affirmatively exclude firearms. Language that reads, in hindsight, like a direct response to concerns raised from the bench during oral argument itself. An attempt by the eventual majority to write an opinion narrow enough to answer the specific objections several justices had pressed the challengers on that January morning, rather than adopting the broadest possible version of the challenger's theory that some of the court's own questioning had specifically tested and appeared wary of. Let's talk about what actually happened procedurally after that January argument, because the 5-month gap between argument and decision is itself a normal, expected part of how the court operates, not a sign of unusual difficulty or delay, and understanding that process demystifies what can otherwise feel like an opaque, unexplained wait. After oral argument, the justices meet privately, typically within days, to discuss the case and take a preliminary vote, a private conference where each justice, starting with the Chief Justice and proceeding in order of seniority, states their tentative view of how the case should come out. Once that preliminary vote is taken, the opinion writing process begins, with the senior justice in the majority assigning which justice will write the majority opinion, in this case Justice Alito, while any justices planning to write separately, whether in partial concurrence or dissent, begin drafting their own opinions concurrently, often over a period of weeks or months, as each justice's chambers works through the specific historical and doctrinal analysis their own opinion requires. Justice Barrett's separate concurrence, partially joined by Thomas and Gorsuch, along with Justice Kagan's separate dissent alongside Jackson's, all had to be drafted, circulated among the justices for comment and potential revision, and finalized before the court was ready to release the decision as a complete package, a process that routinely takes several months even in cases where the outcome itself was reasonably predictable based on how oral argument went. Since the specific reasoning and the precise boundaries of what the majority opinion does and does not resolve still require careful, deliberate drafting regardless of how clear the ultimate vote count turns out to be. Here is what the final vote actually looked like once all of that internal drafting concluded on June 25, 2026, 5 months and 5 days after the argument I have just walked you through. By a 6-3 margin, the court ruled Hawaii's default rule unconstitutional. Justice Alito wrote the majority opinion, joined by Chief Justice Roberts and Justices Thomas, Gorsuch, Kavanaugh, and Barrett, with Barrett's separate concurrence partially joined by Thomas and Gorsuch addressing additional points of historical analysis beyond what the main opinion covered in full detail. Justice Jackson's dissent, joined by Sotomayor, and Justice Kagan's separate dissent, together represented the 3-justice minority whose skepticism had been visible, in different forms, throughout the January argument itself. Jackson through her property law-focused questioning, Kagan through her own separate concerns about the majority's historical methodology that would eventually become the basis for her own distinct dissenting opinion. Comparing that final lineup against the specific questioning patterns from January reveals a striking level of consistency. Nearly every justice's eventual position tracks closely with the specific concerns or sympathies their questions that day revealed, a pattern experienced court watchers rely on precisely because it holds up this reliably, case after case, even though it is never treated as a certainty until the actual written opinion confirms it months later. Step back and look at what tracing this specific argument actually demonstrates about how to read a pending Supreme Court case before its outcome is officially known. The written opinion, when it finally arrives, tends to read as a clean, confident, fully reasoned document, and it is easy to forget that the actual reasoning was tested, probed, and in at least one memorable instance, partially conceded in real time, months earlier in front of a live audience, through the specific questions the justices chose to ask and the specific answers counsel gave in response. Watching or reading that exchange as it happens, rather than waiting for the polished final product, gives you a genuinely different, earlier window into where a case is likely headed, one that experienced Supreme Court watchers have learned to take seriously precisely because it has proven reliable across case after case, this one included, from Roberts's pointed vampire rule question to Kavanaugh's practical everyday errand hypotheticals to Jackson's property law-focused line of inquiry, each one mapping almost exactly onto the position that justice would ultimately take 5 months later in writing. There is a broader lesson here worth carrying into how you follow any major pending case, not just this one specifically. Oral argument gets covered, when it gets covered at all, as a brief news item the day it happens, a headline noting which side seemed to have a rough time at the podium, then largely forgotten until the ruling itself generates a fresh wave of coverage months later. That approach misses the actual substance sitting in between those two moments, the specific, granular exchanges that, read carefully, often preview the eventual opinion's reasoning in remarkable detail, sometimes down to specific phrases and hypothetical scenarios that resurface nearly verbatim in the final written opinion. Treating oral argument as a disposable, one-day news event, rather than as the actual first draft of the reasoning that will eventually decide the case, means missing months of genuine, substantive signal that was available the entire time, sitting in a public transcript anyone could have read. If walking through the actual oral argument instead of jumping straight to the final ruling was useful, hit like so, it reaches people who want to understand how a case like this actually develops in real time, not just its eventual outcome, and subscribe if you have not. Because I will be covering the oral argument in Viramontes versus Cook County this fall with this exact same level of attention to the specific exchanges, not just a same-day summary of who seemed to be winning based on a single dramatic moment. This is exactly the kind of coverage that requires actually reading the transcript rather than relying on a same-day news summary, and it is exactly the kind of coverage I intend to keep doing for every major case worth this level of attention. Tell me in the comments whether you want the next video to trace oral argument in one of the 3 remaining Wolford-related state cases as it happens, or to go deeper into how Justice Jackson's property law framing from that January argument might resurface in a future case testing similar ground, since her specific line of reasoning did not disappear just because it lost this particular vote, and dissenting opinions have a well-documented history of eventually becoming majority positions in later cases once the composition of the court or the specific facts of a new case shift enough to revive an argument that once lost.